Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing K-1 fiancé visas, and we're specifically discussing the issue of the meeting requirement associated with the K-1. For those who are unaware, there are other videos on this channel. You can basically use the search function on our channel to go ahead and search K-1 fiancé visa meeting requirement, and you'll get a couple of videos that go into relative detail on that, as well as exceptions associated therewith. To provide a brief overview, essentially statutorily under the Immigration Nationality Act, those that are seeking a K-1 fiancé visa for a non-American fiancé need to have met that fiancé at least once physically in person within 2 years of filing for that type of visa benefit. There are exceptions to this. There are certain religious situations that may arise where meeting is not going to be possible. There are also health situations where it's simply not possible for the couple to have met in person prior to applying for the petition. But that being said, those exceptions are quite few and far between. I've been doing this for over 10 years, and it's very rare. In fact, I can count it on less than the fingers on my hands where I've dealt with cases where the couple was unable to meet, and in those circumstances where they were not able to meet, the evidentiary burden was quite heavy with respect to proving up the reasons why it was not possible for the couple to meet. But suffice it to say, you effectively need to have met in person at least one time within the 2 years prior to filing for a K-1 fiancé visa. That being said, I get this question rather frequently from people where they basically say, well, I understand we got to meet at least once. Is there some optimal amount of meetings that are going to be better with respect to the K-1? My answer to that is, well, it's all circumstantially dependent. Obviously, the more the better. There is no hard and fast rule with respect to proving up the underlying relationship associated with the K-1 fiancé visa. But that being said, essentially K-1s, the more the better, obviously, but there is no magic number. So the thing to take away from this video is, there is no magic number. And the other thing to take away from this video is, you probably do need to go ahead and meet at least once. And more, especially in light of the fact that USCIS has changed the rules with respect to denial, insofar as they no longer have to issue a request for evidence before denying a K-1 fiancé visa application. It's really, really important to deal with that meeting requirement stuff at the time of the initial filing. For that reason, probably a very good idea to retain the assistance of a legal professional in order to help you and your fiancé go ahead and file a strong visa application or visa petition from the outset, so as to forestall the possibility of denial, or try to forestall the possibility of denial in a USCIS adjudication.